May I ask Lord Denning what you think about the problem of standing, which has been so prominent recently in administrative law, whether the court ought to be open to hear a complaint against some government department or minister or somebody from any citizen who thinks that this ought to be remedied, even though he hasn't himself been personally injured?
Well, that is a very nice question. We've had it from time to time, and objections being taken often on behalf of the Crown or departments saying, this man hasn't got any right to come to the court. He's got no real legal right or interest to sue us or anyone else, and he ought to be thrown out and not heard. Well, you know, there was a well-known person, Raymond Blackburn. A lot of people will have heard of him. He often came before our courts. He came in person. He'd been a solicitor himself, I think, at one time, but he came in person before us, and he took all up these causes. One he took was he wanted to raise the constitutional point. Was it constitutionally right or permissible for England to join the common market and therefore give up some of the sovereignty of our own parliament and king over our people? And he came and raised the point, and we decided it as constitutionally it was permissible for us to join the common market. But that's a very important point, which only Raymond Blackburn, no particular interest in the case at all, any than any other citizen, but he brought it for us, and that opened the way, because then he brought case after case. They're very celebrated, really. The next one was when the gaming people, all these gaming clubs in London, were finding all sorts of ways of getting round the law. One first, as the way they played their games, you know, and they get round the gaming laws in one way or the other. And the commissioner of the police got so tired of all these prosecutions, he issued a policy directive to all the constables round about and saying, well, don't trouble about prosecuting these gaming people. They're always raising some sort of technical point and getting away with it. It isn't worth our policy at all to prosecute them. And Raymond Blackburn, he got no more interest than anybody else. He brought the case before us, and then we allowed him to hear it, and we heard his case. And we said this policy, which was taken up by the police commissioner, was all wrong, and it ought to be altered. And they agreed to alter it and withdraw that directive. And so, in a way, he won the day, and the police had to enforce the gaming laws. But incidentally, I remember that case well, because not only was a nice little cartoon about it in the papers, I told it in my books, but also, it's unusual, but the Secretary of State, the Home Secretary, Mr. Callaghan, asked to see me about it. The case was all over, and as to the policy of new legislation about it. And as a result of that talk and his initiative, the new licensing system was introduced, whereby all these gaming clubs had to be licensed with proper conduct, proper couriers and so on. But that was all the result of the case, which Raymond Blackburn had brought on his own before us, the courts. That was gaming. But he said he was jolly good, he's finding out all things were going wrong. And the next thing he tackled was pornography. He said, well, the police, if you go to these shops in Soho, they're selling all this pornographic stuff all around, and the police aren't taking any steps to stop them at all. And he brought his case before us. Well, he said, well, he hadn't got any more interest than any other citizen, but he was, as a father of a family, he didn't want his youngsters seeing it. And he said, well, I can go into any of these shops in Soho, I can buy all this pornographic stuff. And so he brought his case. What they took objection to is bringing it. We said we would hear him, and we did. And you know, and it turned out to be right. We were very anxious about the conduct of the police. They were turning a blind eye to it sometimes, And I'm afraid it afterwards turned there was a good deal of corruption going on, bribery, so as to protect these shops and so. And I remember Raymond Blackburn, he said, oh, well, they're properly on sale. You go out at lunchtime and bring this stuff back to us. We'd say, it was the most appalling stuff. I told them it had to be kept in the safe. It was so appalling. I didn't want other people to see. It was the most appalling, rubbishy stuff. Well, there, we heard Raymond Blackburn. We upheld him, held his complaint. We would have ordered and made an order against the Commissioner of Police himself, a mandamus for him to do his duty, except Sir Robert Mark was the newly appointed commissioner, and he said, well, I'll put things right. And quite rightly, we trusted Sir Robert Mark, and he did wield out all that corruption. He did a marvellous job in that corruption among the police. But the initiative, everything sprung from that case which Raymond Blackburn, on his own, a private citizen without lawyers, brought before us. But he didn't end then. There's one more case. The Greater London Council have a power of censorship over what should be shown in cinemas and all that sort of thing. And he said they weren't exercising their powers of censorship rightly. They were letting things through for children which oughtn't to let through and so forth. Raymond Blackburn again complained to us, and we held again that he could properly come as a private citizen and complain. And we held, I think the GOC were not, and they had to put things right as to their powers of censorship. But there you are, Raymond Blackburn, a private individual with no greater interest than any other person in the land. We held in all these cases he was entitled to come as a public spirited citizen and ask the judges to see the law was enforced as we held it should be. Those are the Raymond Blackburn cases.
Isn't it the fact then that unless you allow somebody like Mr. Blackburn to come in the guise of just a public spirited citizen, you have a situation where nobody could see that the law was obeyed? Because if the courts are strict about standing and insist that you shall have some personal injury before you can get into court, there are so many situations nowadays where some government department has some power, like controlling the films to be shown in London on the part of the GLC, and there's nobody particularly concerned, so that unless anybody can sue, then nobody can sue, and they can just disregard the law.
Well, there, you know, I don't know whether you remember the case Ross McWhirter. He came to us one afternoon at 3 o'clock in the afternoon, and he said there's going out on the television tonight an absolutely shocking film, all about Andy Warhol, and he said it's an absolute shocker, it oughtn't to be allowed to be shown. And he asked us to make an order restraining it. I said we didn't know all about it in the end, but he produced newspaper reports and the like, and we thought the position ought to be protected. And we granted an injunction. I forget which television lot it was, but all of it to stop this Andy Warhol film being shown at all. Had Ross McWhirter any standing to come before us? He'd asked, I think, they said, oh, we ought to get the Attorney General to come in. And we said, well, we could hear him even if the Attorney General might refuse to come in, we'd let him come in. So we let Ross McWhirter came in, and I think the Attorney General afterwards was there. But at all events, the injunction was, they stopped it until we saw it. And we went and saw this film. It was the dreariest, dullest film you ever saw. And we didn't mind that being shown in any way. But that, I thought it was called him the courageous Mr. McWhirter. Because after all, he was the one, you know, who was murdered at his doorstep in London somewhere by some other people. So he was courageous enough to come before us, and we there laid down what I think is the right principle. That any citizen complaining of any wrongdoing or anything contrary to law by a government department, any citizen, as long as he's not a mere busybody, can come before the courts and asked the courts to intervene.
But hadn't the House of Lords got something to say about that when the Gourier case came up?
Well, they said I was wrong. They've said that before, you know, from time to time. Of course, the Gourier case, if you're going to mention the Gourier case, well, there it is. Well, I still feel we were right about that. The Gourier case was this. I think on a Thursday afternoon, some trade union people said, we don't like what's going on in South Africa. We're going to stop all communications, the post office and everyone, between England and South Africa. We're going to have a strike for a week on from Sunday night. That was on a Thursday. Well, Mr. Gourier, I think he's the secretary of some freedom association or something of that kind, he came before us and said, well, this is contrary to the law. There's a law which says no one must stop the mail. And we looked at this law, and he was right. There's an absolute statute still in force saying that no one must interfere or delay or hinder the mail. And we granted an injunction against the Union of Post Office Workers and the like, simply following the very words of the statute, enforcing the law, prohibiting any interference with the mail. And that's the injunction which we ordered, in the very terms of the statute. And when the Attorney General came up and said we couldn't do it, he came up to my court and said he couldn't do it. I said I wasn't going to have too much of that. Any citizen, I said, could come. And I said, be you never so high, the law is above you. And they all quoted that. I was quoting an old writer years ago. So that's what I said to the Attorney General. But there we were overruled. I still think we were right, but still the House of Lords in that case said that my previous statement was wrong. One I'd quote about Mr. McWhirter, and they said that, and they overruled it. Of course, they think we'd cured it by that time, but the injunction which we'd granted had stopped the strike, and we were right. And they were dealing it from a mere academic point of view and saying we ought never to have done it. We've done and got it through. But still there we are, they overruled us in that, and I don't agree with it.
Didn't the Attorney General tell you on that occasion that an Attorney General was a political animal?
Yes, when I said, well, look here, he may interfere on party political grounds, and I wasn't going to have that. And also, there is the danger of the House of Lords decision. They said it was only for the Attorney General to enforce the criminal law.
And the public interest.
And the public interest. It's only for the Attorney General. The courts couldn't do it, and no individual could bring it before it. But that's, I'm afraid I took exception, but still, they've overruled me. I can't go any further. Only for the Attorney General to do it.
But still, you've had your comeback now, because in the case, commonly known as the Fleet Street Casuals case, I think the House of Lords upheld the sweeping constitutional principle that you laid down in the McWhirter case about anybody being entitled to come.
Well, now you that's the most interesting thing. It was Lord Diplock really eventually who proved it, but you ought to know about that. We call it the Fleet Street Casuals case. You know, these men who were casually employed on the newspapers and so forth, the printers, they were all members of their union, and the work was allotted to them amongst the newspaper printers on Fleet Street and so on. And when they went to draw their wages or their pay, they signed in false names. One said Mickey Mouse, and the other would some racehorse jockey or whatever it may be. At all events, they invented names to sign for their pay. And the reason was they couldn't be chased then by the tax people. If the tax people said to the, well, how much money did you get? Oh, well, Mickey Mouse got that, and not John Smith. But the trade unions had got the names, the true names of Mickey Mouse, whether it was John Smith or Peter Jones or whatever it was. The trade unions, and they wouldn't give up the names, you see. Well, then, So all these Mickey Mouses were getting out of their taxes. They weren't paying their right taxes. Well, a lot of small shopkeepers and roundabout in London, they didn't like this at all. And in fact, the Inland Revenue granted an amnesty. They said they wouldn't go for all these past taxes, or which they hadn't paid, as long as they behaved well in the future. Well, a lot of these young shopkeepers around there, self-employed, said we don't like this at all, and they got their federation to bring a claim saying, well, they oughtn't to give an amnesty to let these people off the taxes which they ought to have paid. And so those Fleet Street, so the self-employed people, the federation, brought the case before the courts. Could they complain of what the revenue had done, granting an amnesty to these people who had defrauded the Crown of the taxes? And the big point in the case, which was, could this Federation of Small Shopkeepers bring the case? Well, there. We held in the Court of Appeal by a majority that they could. The House of Lords reversed us in rather a narrow point, because they said on the evidence as they saw it, there was really no merits or no strength in the shopkeeper's case at all. The Crown and the people who were managing the taxes had a wide range of discretion in the way they managed affairs, and so there was no bottom and no substance in the shopkeeper's case. But they, at the same time though, Lord Diplock, not all the others, but Lord Diplock in particular, said apart from that one point, if there had been any merit in the case, any substance in it, then any citizen could bring, as I've said, a case. And he affirmed, and I'm glad to hear you say it, the principle which I tried to state, I called it a high constitutional principle in Ross McMurtough's case, that any citizen who's genuinely aggrieved by the misconduct of any government department, however high, he can bring his proceedings to the judges and ask the judges to interfere. At all events, I would always do so, I always did, and I think and hope that principle is now, not a mere busybody, we wouldn't look to a mere busybody, but anyone who had a sufficient interest to bring the matter before the courts, we would hear him as I always did, whether they were in person like Mr. Blackburn, in person like Mr. Blackburn, or with counsel and lawyers as the shopkeepers. I'd hear them all and see that these departments obeyed the law.
So this seems to have vindicated your earlier judgments very strongly in principle, although in the result the House of Lords held that the complaint wasn't strong enough to succeed.
Yes, that's how they put it, but in a way I wish they'd been a bit stronger and upheld me altogether. But still, that's the sort of the thing. But all of it, the important thing is, and I hope, it is a great case, I hope that the principle is established, that any ordinary citizen, high or low, can come to the court against any government department, ever high or low, and say, are these people doing their duty? Are they obeying the law or not? And I hope the courts and judges will always see to it that they get hearing and get redress if justified.
Don't you think we ought to do some technical sorting out of these cases for a moment or two? Because we've been talking indiscriminately about a number of cases where very different remedies were asked for and awarded. One lot, like Mr. Blackburn's cases, come under the ancient prerogative remedies, certiorari, mandamus, and so forth. And I think it was an order of prohibition, one of those remedies, which you gave him, or in effect gave him, against the GLC. Whereas in the McWhirter case, it was an application for an injunction, which is a private law remedy. And isn't it right that the ancient remedies, the prerogative remedies, are always at the suit of the Queen? It's the Queen against the Greater London Council on Mr. Blackburn's behalf. Any citizen can borrow them, so to speak. So it's the principle wrapped up in those old remedies that they are for public benefit and public order and public interest that any citizen can have because it's the Queen's name, just like a habeas corpus case. Now, don't you think that's a vital element in our legal system which does justify the principle which you have always fought for?
Yes, in the old remedies, we had them, they were the names certiorari, prohibition, and mandamus. They were all in the name of the Queen. And therefore, in a way, in theory, any individual could, as long as the courts would entertain it in their discretion, any individual could come and ask the courts to intervene. And that principle is capable of elaboration. I think, I don't know, we shall have to deal with it on a new system of judicial review, which has been introduced. You'll find that that principle may be being widened considerably now, but sufficient for the present purposes, with all those various remedies, whether it's injunction, prohibition, or mandamus, or whatever it may be, they are now, I think, being made available to every ordinary citizen in the land, and should be, if justice is to be done.
I'm tempted to remind you that in the first of the Hamlin lecture series that you gave very many years ago, I think in the 1940s, you said in a very famous passage that just as the pick and shovel were no longer any good for coal mining, just so the ancient prerogative remedies ought to be replaced by newer ones like injunction and declaration, which were the right remedies for the new legal age. But it does seem now that there is this very important element of public interest and public law in the prerogative remedies, and those ancient remedies are, of course, doing extremely good service in the sort of cases we've been discussing.
Well, I wrote those Hamlin lectures and delivered them in the year 1949, when all our administrative law was at the nadir, the lowest point of all. And I then said that all those old remedies weren't serving the modern age as then interpreted. That's over 30 years ago now. Now, I am glad to be able to say, and I think we've had a little part in it, we have developed it. It's in those last 30 years where now the remedy available to the individual citizen who's aggrieved is available in the courts against any government department, however powerful it might be. So I think we have got now a real system of administrative law.
I think